go on the record in the matter 25 TR 103, 1033, 1034, and 1035. State of Wisconsin versus William Holmes. The state appears through District Attorney Kevin Schmidt in person. Mr. Holmes appears in person without counsel. We're set today in these matters for status conferences. Mr. Holmes, are you in the process of getting your license?
I'm sorry, I couldn't hear you.
Are you in the process of getting your license?
Yes, I am.
And where are you in that process? What do you have to do?
Well, I've been in contact with Aurora, and I got an appointment with them tomorrow morning for assessment.
Excellent.
And I got my registration, and I haven't got the insurance yet.
All right. So you're just operating while suspended, so it shouldn't take you that long to get that all up and running? To get your license, how long do you think it'll take you?
I'm sorry.
How long do you think it'll take you to get your license?
I don't know what the assessment's going to save, but I'm thinking 30 days.
Well, let's say June 8th at 11:30, okay? June 8th at 11:30. You can come up here and get a notice and then come back on that date and time. If you already have your license before that date and time, bring it to Mr. Schmidt over there, his office, okay? Because you won't need to appear at that next hearing, because I can't recall, but I'm just gonna say that if he gets his license, they're all dismissed.
The offer is if we get the proof of the insurance, the registration, and the license, then we'll dismiss it. So we do need all three of those.
Do you have the registration right there?
Yeah.
Can we take care of one right now? Get rid of at least the
If
registration?
you could bring it to our office to make copies of it, I'd appreciate that.
Oh,
So
it
it's
is?
just down the hall.
Okay.
Yeah, so just go to his office, let them make copies of your registration, then get your insurance and get your license and bring them here so they can copy those two, and then you're good to go.
Okay.
Okay, so come up here and get your notice, okay? We will go on the record in the matter 26 TR 52, County of Burnett versus Pavel Ozerkov. Appearances are the state appears through District Attorney Kevin Schmidt in person. Mr. Ozerkov fails to appear. He had valid notice of today's date and time. He entered a not guilty plea on January 26, 2022. He was given this date and time at 9 a.m. Weather is great. He can drive with good driving conditions, no call to the court. The court is going to find him in default for his failure to appear here today. I'm going to assess $213. Excuse me.
Could I ask that be $100 less? This individual contacted us, started the diversion program, paid $100, and then disappeared. I was kind of hoping he'd be here today. So just to benefit him on that end.
Okay, because he's already paid $100?
Yes.
To you. All right, so I will find him in default. I will assess, well, I'm gonna do $115, 3 points off of his license. He has 30 days to pay. Failure to pay means the court will issue a warrant. He could sit up to 6 months in jail, or the court will enter a civil judgment against him because he will always owe that. We are adjourned. All right, Mr. Maddie. Now I feel like I'm yelling because the other guy couldn't hear me.
I said he could hear.
Yeah, he did. Well, not back there. We will go on the record in the matter 25 TR 1023, State of Wisconsin versus James Maddie. The state appears through District Attorney Kevin Schmidt in person. Mr. Maddie appears in person without counsel. We're set here today in this matter for a court trial. This is a speeding matter in which it is alleged that you were speeding 20 to 24 miles an hour over the speed limit. Mr. Maddie, I believe that there's information that you have been informed of a diversion program through the district attorney's office, and I think you have declined that and you wish to proceed with a trial. Is that correct?
Yes, because I couldn't see paying an extra $100.
Well, here's the deal. I'm gonna tell you, I will give you an opportunity to think about this or to talk to the state about this. If you are found guilty of this speeding offense, this is a 20 to 25 or 20 to 24 mile per hour over. If you're found guilty, you lose your license.
Hmm. Well, first of all, I'd like to know how the officer,
Well, if you want a trial, then we're more than welcome to have a trial. That's your right. I just want you to understand the ramifications of what could happen if I hear all of the evidence and all of the things and I find you guilty of this exact offense. Bye-bye license. So you won't be able to drive. Okay, so you're gonna have to do all kinds of programs anyway to get points back and to wait some time and to have those things. If I go through and I have a trial and I find you guilty, there's no more wheeling and dealing. There's no more trying to work and play with the district attorney's office, because if we're having a trial, we're having a trial and the ramifications will speak for itself. I just want you to be aware of that before we proceed, because you're not here with an attorney and it's not my job to give you any type of legal advice or legal consultation, but I do want you to understand the potential ramifications of a guilty verdict.
do I have a right to have an attorney?
You have a right to hire your own attorney, yes,
I
not a
can't-
public
I don't
defender.
got the money for that.
Well, then that's what it is. So
Don't you
that's
have public defenders?
not for a ticket. It's a ticket. If it were a crime and you want the district attorney to charge you with a crime, I'm sure then we can go ahead and get you a public defender. Raise some ruckus, get a disorderly conduct charge, and we're good to go.
I'm just curious, how did he ascertain a 75 mile an hour?
If what I'm hearing is you want a trial, this is your time to have a trial. You have me until, as long as this goes. But if you want to think about it, although we do have our state trooper here who is ready, willing, and able to testify and has now taken off his duties of patrolling and all of the other things. If you want to have time to talk to the district attorney right now, because you're thinking about it, you sure can. Otherwise, we will move forward and have your trial here today. I want you to be well informed.
Sounds like blackmail, but I'll talk to the.
It's not
I'll talk-
blackmail. Your
I'll
rights
talk
are
to
your
the
rights.
attorney.
Your rights are your rights. And I'm
an old crippled up disabled war veteran.
and
I
respect
fought for
you that.
rights. I fought for your rights.
And I respect every single veteran that we have, even the ones that are having issues after their service. Thank you for your service. I understand that, but still the laws are the laws are the laws, and you fought to protect our country and to defend our laws. Okay? And so that's why we are here. So if you want an opportunity to talk to the district attorney, I'm more than willing to give you some time. If not, we are ready to go, and I'm ready to hear the evidence here.
Yeah, I'll talk to him.
All right, thank you. Okay, so we will briefly adjourn until we can come back. Mr. Schmidt and Mr. Maddie, please go outside.
This is where the courtroom dynamic completely shifts. Up until now, James Maddie is pushing back, questioning the officer, and clearly feeling like the system is stacked against him. But the judge steps in and lays out the real stakes. If this goes to trial and he loses, he could lose his license entirely. That moment changes everything. Suddenly, what looked like a simple speeding ticket becomes a high-risk legal gamble. And that's something many people don't realize. Sometimes fighting a charge in court can expose you to harsher penalties than negotiating a plea. What makes this moment especially compelling is the emotional tension. Maddie feels pressured, he even calls it blackmail, while the judge insists he's simply explaining the consequences. Was the judge being fair and transparent, or did that warning push Maddie into backing down? That's the big question here, because once the defendant realizes the possible fallout, the confidence to fight often turns into the fear of losing. And right here, that fear forces a major decision: trial or deal.
On the record, same appearances as previously noted. Mr. Maddie has had an opportunity to discuss the issue with Mr. Schmidt. Mr. Schmidt, how is this matter proceeding?
We've reached an agreement. Mr. Maddie has agreed that he would plead to speeding 11 to 15 over for 175.30 and 4 points.
And 4 points. All right, do you need to discuss that with the trooper or you're good to go?
No, I'm good.
Okay. So, Mr. Matty, you wish to accept an offer from the state of a reduction from 11 to 15 over at $175.30 and 4 points off of your license?
Yeah.
Okay.
How long do I have to pay that fine?
I can give you time. I'm gonna guess you're on a fixed income and all of those kinds of things.
Well, I don't get my social security till about the 5th of the month.
I'm good. So a formal motion to amend
So made.
granted. How do you wish to plead?
I'll plead guilty to that.
The court will accept your plea of guilt with regards to that matter. I'm gonna do you one better. I'm only gonna assess $150,
Thank you.
okay? 4 points off of your license, $150. Do you want to pay it all in full with your next check, or do you want a payment plan?
I think I can swing it on my next check.
All right, so I'm gonna say it's going to be due by June 15th, so you can figure that out, okay?
June 15th.
Pay in full by June 15th.
Oh, this is April, May and June. Yeah, I think I can pull that off.
Okay, and is your address still 2481 240th Street in Cushing?
Yes.
Telephone ends in 1342?
What was it?
Your telephone, does it end in 1342?
Yes.
Okay, thank you. All right, then we are adjourned.
And
Just keep your pedal off of the metal or whatever that's called. Just go a little bit slower.
yeah.
All right, thank you.
In the end, this case wraps up with a negotiated plea. But the journey to get there says a lot about how courtroom pressure works in real time. James Matty entered this hearing ready to fight the speeding ticket, skeptical of the diversion offer, and demanding answers about how the officer determined his speed. But after hearing that a guilty verdict at trial could cost him his license, he chose to accept a reduced charge instead. The original allegation of speeding 20 to 24 miles over the limit was amended down to 11 to 15 over. The fine was reduced, and the judge even lowered the amount further to $150. From a legal standpoint, this was a practical outcome. Matty avoided the harsher penalty, and the court resolved the matter efficiently. But from a viewer's perspective, it raises an important question. Did he truly make that choice freely, or was the risk of trial too intimidating to ignore? That tension between choice and pressure is exactly what makes courtroom negotiations so fascinating. Cases like this remind us that legal outcomes are often shaped as much by strategy and fear as by facts. If you found this courtroom moment as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more real courtroom breakdowns and legal analysis.